An agreement requires offer and acceptance. We've already looked at the concept of offer. Now, let's examine its counterpart, the acceptance. Once a valid offer has been made, this gives the offeree the power to accept the offer. If and when that happens, a contract has been formed between the parties. That is, between the offeror and the offeree. A valid acceptance has the following elements. There needs to be an objective intent to accept an offer. The acceptance has to mirror all the material terms of the offer. This is known as the mirror image rule. And the offeree needs to communicate the acceptance to the offeror. Let's also look at these requirements in some more detail. Whether someone has manifested an intent to accept is once more interpreted according to the objective theory of contracts. The question is, therefore, whether a reasonable person in the shoes of the offeror, the person that made the offer, would find that the words or actions of the party receiving the offer are an acceptance. Again, subjective elements such as jokes or not being serious about an acceptance are immaterial if they are not obvious to a reasonable observer. The common law mirror image rule provides that the acceptance should be the mirror image of the offer, that is, not materially change the terms of the offer. If the acceptance materially changes the offer, then the original offer has been rejected and instead a new counteroffer has been made, which the original offeror could now accept. For example, let's say that someone says to you, "I would like to buy your car for $15,000. And you respond, "Okay, I will sell it to you for $20,000. In that case, you did not accept the offer. Instead, you rejected the original offer and made a new offer yourself. This new offer for a sale of a car for $20,000 can be accepted, but the original offer, unless renewed, is off the table. The acceptance has to be properly communicated to the offeror in order to be valid. This can be done in various ways, although if the offeror specifies that the offer needs to be accepted in a particular manner, then acceptance by any other method is not valid. For instance, the offer could stipulate that acceptances have to be in writing or via email or post. Oral acceptances would in such cases be invalid. If no particular method of acceptance is stipulated, then the common law mailbox rule applies. This rule provides that an acceptance that has been communicated using an authorized method is valid as soon as it is dispatched. That is, at a point in time when the offeror may not yet have received the acceptance. For instance, when someone mails an acceptance to the offeror, the acceptance becomes valid when the letter is dropped in the mailbox. The requirement of using an authorized means of acceptance is met when the party attempting to accept uses either the method of communication that the offeror used or uses a faster method of communication than the offeror. Hence, the acceptance cannot be used using a slower means of communication. For example, unless something else is stipulated by the offeror, a mailed offer can be accepted by mail, the same method, or email, which would be a faster method. The mailbox rule also provides that if an acceptance is made using an unauthorized means, or if the acceptance is not properly dispatched, then the acceptance is only effective on receipt, not on dispatch. An example of unauthorized means would be accepting an emailed offer using regular mail. This would be a slower method and therefore unauthorized. An example of an improper dispatch is using the wrong address or postage on letter. But again, the mailbox rule is a default rule. It only applies when the offeror doesn't expressly specify the requirements for acceptance.